Good afternoon, everybody. Welcome and thank you for joining us for today's presentation. My name is Matthew Curtin, and I'm a member of the Labor and Employment Group here at Merthyr Kalina. Today I will be talking with you about handbook policies, why employee handbooks are important, best practices, and the ever-changing legal landscape. First, I'm going to take a moment to go over a couple of housekeeping items. All callers are currently in listen-only mode. If you have questions during the presentation, you can write them in the questions box of your webinar toolbar, and we will answer them at the end of the presentation if there is time. This webinar is being recorded. All of today's participants will receive an email following today's presentation with the PowerPoint slides, a link to the webinar recording, and an attendance certificate. So let's get started with the presentation. Why employee handbooks are important, best practices, and the ever-changing legal landscape. I'm excited to present on this topic today because there has been so much change in the area of work rules and applicable laws between jurisdictions, different states, and I think it's a very interesting topic to go over with HR professionals. An overview of the webinar. Why have an employee handbook? I got some emails before this webinar asking me to start kind of at a basic level of why it's important to have an employee handbook, what might be a required policy for employee handbooks, and also what might be some of the associated risks. So I'm just going to go over at the beginning of the webinar some of the basics of employee handbooks. Then we're going to get into hot topics and work rule law. Very exciting. A couple things I want to point out for everybody and go through in a little bit of detail. One thing that I think will be very helpful for everybody is the discussion about the NLRB's balancing test concerning work rules. This is a test that's been in place for about 14 months now as a result of a decision called the Boeing Company that was issued in December 2017 by the National Labor Relations Board. Even though it's a decision that was issued by the National Labor Relations Board, it is a decision that's important for unionized and non-unionized workforces because it impacts organized and unorganized employee workforces. And finally, we'll close out the webinar with a discussion of best practices for employment handbooks. So why have an employee handbook? Well-drafted handbook sets workplace rules, expectations, and requirements. It can also lend to company branding and company culture, which I think is a very important aspect of employee handbooks that are often overlooked. I will say many times I find that employers don't want to put a lot of time or effort into their employee handbooks, which I think can be a huge mistake because it's a perfect opportunity to brand your company and the type of culture that you want for your workforce. I think that employers that don't put the time and effort into crafting and maintaining a well-drafted employment handbook are really doing a disservice to their organization and missing a great opportunity to sell itself to its workforce and to maintain the kind of culture that it wants. Also, an important part of employee handbooks, and this is what I get most involved with, is the litigation risk mitigation. Now, that's only if an employee handbook is properly drafted, implemented, and followed. Now, if an employee handbook is not properly drafted, implemented, and followed, it can present the opposite of risk mitigation. It can actually create risks for the employer. Brings us to our next slide. Are there risks in maintaining an employee handbook? Simple answer, yes. Poorly drafted employee handbooks can alter, for example, the at-will nature of an employment relationship. A poorly drafted employment handbook can create binding contractual promises that the employer did not intend and can result in litigation that is not easy to get out of. Ignoring state or municipal requirements that differ amongst different jurisdictions from state to state. If employers are not aware of the different laws that might apply to their entity, based on the different jurisdictions in which they are operating, they're doing themselves a great disservice and creating what could potentially be large litigation risk. Also, employee handbook provisions that are overly restrictive and that restrict operational flexibility and disciplinary authority. Often I will see employee handbooks that are drafted in a way so as the employer really leaves itself very little flexibility in what it can do to discipline employees. Operational flexibility is limited. An example of the disciplinary authority issue is if an employer lays out a bullet point list of these are the issues that we will discipline you for, and this is the exact corresponding type of discipline that you will receive for these types of offenses. Now, most employers are smart enough to leave themselves some sort of operational discretion and in saying something to the effect of giving an exemplary list of offenses that could lead to discipline up to and including termination. So you want to make sure that as an employer, you're giving yourself the flexibility to implement discipline as you see fit, but while giving examples of the types of conduct that are applicable to your workplace that you think need to be pointed out so that employees are aware of what the expectations are and what the work rules are that they need to follow. So must-have policies. So I'll qualify this discussion. The next few slides are going to discuss must-have policies, and I'm only going to highlight a handful because the spectrum of must-have policies differs due to a variety of factors. The type of workplace, the type of employer, the number of employees can impact the type of policies that you must have. The different jurisdictions in which the employer operates can affect the types of policies that an employer must have, and we can't cover the entire spectrum of that in today's webinar because it really takes a case-by-case analysis of an employer's operations to figure out exactly what are the must-have policies for any given employer. But there are a few policies that we can point out that I think are applicable to pretty much every employer. And so the first one I'd like to point out is at-will employment disclaimer. I think it's paramount to have an at-will employment disclaimer where applicable because you want to make sure that there's a clear understanding between the employer and the employee about the nature of the employment relationship. An example of an at-will employment disclaimer is your employment with the employer is at will. Either you or the employer may terminate the relationship at any time for any reason, with or without cause or notice. And this is going back to associated litigation risk. The failure to implement an at-will employment disclaimer or a poorly drafted at-will employment disclaimer or failure to get employees to acknowledge the at-will employment relationship can lead to breach of contract claims, breach of implied contract claims that can be very difficult to get out of because you don't have a clear written policy showing what the nature of the employment relationship was, and you weren't able to, in some instances, if you don't have an acknowledgement, you can't even show that the employee ever received the handbook or the at-will employment disclaimer from the employer. So you want to make sure that it's a clearly drafted at-will employment disclaimer, that it is given to the employee and that the employee acknowledges in writing that the employee has received and understands the at-will employment disclaimer. And that can be done as part of an acknowledgement of the overall handbook. But I think one of the best practices and something I like to do with all of my employment handbooks is include at the end of the handbook a comprehensive acknowledgement that restates the at-will employment disclaimer and makes clear that the employee is signing off on an understanding of the at-will employment nature of the relationship. Now, clearly, that can change in some instances. Obviously, if there's employment agreements where the at-will employment relationship has been altered, you can account for that in a handbook. And we're going to discuss that a little later down the road. And another thing to keep in mind is unionized employers. Obviously, collective bargaining agreements can alter the nature of the at-will employment relationship. And where applicable, it's often prudent to include disclaimers applicable to unionized workforces stating that it's at-will employment unless otherwise altered by a collective bargaining relationship. So that goes back to the fact that you just have to have an understanding of the type of employer that you're dealing with and the nature of its operations and its workforce. Must-have policies, contract disclaimers. I've included a comprehensive disclaimer here just as an exemplary disclaimer. Obviously, the contract disclaimers can take many shapes and sizes, but I think that it's, again, like an at-will employment disclaimer, it's very helpful to have a contract disclaimer to try to avoid breach of contract claims because, again, I see these come up often in employment lawsuits. It's a very easy tack-on claim, a breach of contract or implied contract, and if you have unclear handbook provisions or you fail to include appropriate disclaimers, it's very difficult to get rid of these kinds of claims on a motion to dismiss or a motion for summary judgment because it becomes a question of fact that's reserved for the jury or the judge as applicable. One thing I'll point out in this particular exemplary is the last paragraph, and I really like this provision where it says, other than a written agreement signed by the company's president, no one may create an employment agreement with an employee. Now, I like to include something like that in pretty much all of my handbooks because this is one thing that you do see come up in litigation fairly often, is that even though you might have an at-will employment disclaimer and you might have an acknowledgement, employees claim, well, my supervisor said to me that I was going to have indefinite employment through 2022 and that I couldn't be terminated for any reason. My supervisor promised me that I could only be terminated for just cause. Or my supervisor gave me some other document that he or she told me supersedes this document. And those are all attempts to try to get around at-will disclaimers and contract disclaimers. So it's nice to have in writing that the only way to enter into an employment agreement with a particular employer is in a written agreement signed by, for example, the company's president or he or she's designee, some appropriate individual. But it's very helpful so that if there's ever litigation over the issue, you can point back to this disclaimer and say the plaintiff has not produced any written agreement signed by the appropriate designee altering the at-will nature of the employment relationship or making whatever promise the employee is saying that the employer made. And that could be very helpful for purposes of trying to get rid of a case before going to trial. Another important aspect of this example is that the company may change its policies and procedures at any time. You want to make sure that you give the company operational flexibility like we talked about. Employee handbooks are dynamic. They're not static. They change over time, or at least they should. I see many that haven't changed in a very long time and they're woefully out of date. But employee handbooks, good employee handbooks are dynamic. They should not be static. They should be changing as laws are changing, as the company is changing, as operations are changing, as needs of the company are changing. And they should be monitored and revised as appropriate on an ongoing basis. And you want to make sure that as an employer, you're reserving to the company the discretion to alter the employee handbook at any time for any reason so that you're not binding yourself to prior policies that might be stale, out of date, or out of compliance with new laws. Another must-have policy is a EEO policy. Now, this is important because you want to make sure that it's in writing that the employer's policy is to prohibit discrimination against applicants and employees based on whatever protected characteristics are relevant to your jurisdiction or the various jurisdictions you're operating within. For example, race, age, sex, sexual orientation, gender identity, etc. One point of advice is that multi-jurisdiction employers should err on the side of caution and be over-inclusive about the protected categories that they designate in their EEO policy. You don't want to get caught short on excluding a protected category that might be protected in, say, Massachusetts or Connecticut, but is not protected by federal law, for example, sexual orientation. Some questions that you might want to ask yourself about an EEO policy. Does it address all the protected characteristics under federal, state, and local laws? We haven't talked about local laws yet. One thing that we're starting to see over the past several years is that municipalities and localities are coming up with their own sexual harassment or anti-harassment laws or discrimination laws. So not only do you have to do an analysis of federal law and state law, you also have to look at the municipalities in which you're operating to determine whether they have any laws on point that require any specific policies or protections for your workforce. Does the policy address who is covered by the policy, such as applicants, employees, interns, independent contractors, if applicable? Again, these are all employer-specific inquiries. Does it prohibit retaliation against applicants or employees for filing a complaint or participating in an investigation? Does it stress that all employment decisions are based upon an employee or applicant's qualifications and capabilities to perform the essential functions of a particular job without regard to protected characteristics? Does it state that it governs all aspects of employment, including hiring, selection, training, benefits, promotions, compensation, discipline, termination? I think those are all important aspects of an EEO policy that employers should consider including. Does it urge the reporting of all instances of discrimination and offer employees multiple avenues through which they can report potential violations? Does it state that appropriate disciplinary action, up to and including immediate termination, will be taken against any employee who violates the EEO policy? Those are all important questions to ask when drafting an EEO policy. Another must-have policy, and I think everybody on the line is probably aware of and if not, we're going to talk about this in some detail. Anti-harassment policies. Now, I'm not just talking about sexual harassment, anti-sexual harassment policies. I'm talking about anti-harassment policies. It used to be the case a long time ago, not even a long time ago, but maybe even 5 or 10 years ago, that you would just see sexual harassment prevention policies. I've started counseling for several years. I've been counseling my clients to include overarching anti-harassment policies that aren't just focused on sexual harassment per se, but on any unlawful harassment. So one thing, and I'm going to go 4 aspects of an anti-harassment policy that I think are essential. You want to define what harassment is. You want to give examples. You want to implement a very clear and robust complaint procedure, and you want to include a clear no retaliation policy for anybody who makes any complaints of harassment or participates in investigations of harassment. Going back to the complaint procedure, just to discuss that in a little more detail, it's important to include various avenues for complaints, and this can be particularly difficult with smaller employers that maybe don't have an HR department or really don't have many employees at all. But the Connecticut Fair Employment Practices Act, for example, applies to employers with 3 or more employees. So even if you are a small employer, you have there are protections for your employees, and there's requirements as an employer that you need to abide by. So you need to make sure that no matter the size, large or small, that you're providing a robust complaint procedure with multiple avenues for complaints. And why do I say multiple avenues? Well, I can say that in many of the cases that I've read and some of the cases that I've handled concerning complaint procedures, it's often said that employees did not complain because they felt that they didn't have the proper avenue to complain. One example, you see a policy that says if you have any problems that implicate the anti-harassment policy, go to the CEO. Well, what if the CEO is the person that is the alleged harasser and there's nobody else designated in the complaint procedure? That's a real-world example that I've seen where employees have said, the CEO was the harasser. I didn't feel that there was anywhere else to go because the policy said that I had to complain to the CEO, or the director of HR is the person that fields the complaints. But the director of HR is the person that's allegedly committing harassment. So if a employee does not feel that they have a proper avenue to complain, then a complaint procedure is not going to be much help in mitigating litigation risk or avoiding harassment in the workplace. Other notable policies that should or must be considered based on the jurisdiction in which you're operating: reasonable accommodation request policy for individuals with physical or mental impairments that could be considered disabilities under applicable disability laws. Electronic monitoring policies, for example, in Connecticut, if you're going to monitor employees electronically, you need to have a policy that informs employees of the manner and methods of the electronic monitoring that the employer is engaging in. Electronic recording policies, we're going to discuss that a little more later in the presentation, but the electronic recording policies can be very important, for example, in hospitals or healthcare employers, so that employees are not recording discussions with patients that might implicate protected health information. Lactation policies, obviously many states, the majority of states I think at this point, have lactation statutes that provide that employers need to provide a mechanism and a room or a procedure for mothers to engage in lactation. Benefits policies. Now, benefits policies can mean a lot of different things. Let's talk about healthcare benefits, though. I don't like to include very specific healthcare benefits policies in employment handbooks because healthcare benefits policies are dynamic and can change from time to time as well. And I don't think that you want to be amending your benefits policy every time you decide to switch policies or change certain aspects of your policy. So I like to let the plan descriptions or the summary plan descriptions dictate the terms of the benefits policies, also because you don't want to have any language in your handbook that contradicts the plan descriptions. It makes it unclear or conflicts with the plan descriptions. But one thing that I think is useful is to describe eligibility and procedures for availing yourself of health care benefits. Other types of fringe benefits like life insurance, leave, we'll talk about leave a little more. Those should also be addressed, can be addressed in handbooks, but they could also be addressed in other manners as well. Drug and alcohol policies, a little bit of a lightning rod right now, and a little bit beyond the scope of what we're talking today, but obviously drug and alcohol policies have been the subject of much debate because of the widespread legalization of marijuana in either a recreational or medicinal fashion. I believe at this point it's at least 28 different states have legalized marijuana either recreationally or medicinally. So the problem with that, I think, is that it's still illegal on the federal level. Marijuana is still classified as a Schedule I controlled substance. So we're still seeing a lot of difficulties with crafting drug and alcohol policies that employers are happy with and that can sustain legal scrutiny. For this particular type of policy, if you've not reviewed your drug and alcohol policy in the very near past, I think that you'd be well advised to revisit that policy and make sure that it doesn't conflict with any of the recent state laws legalizing marijuana in one fashion or another. Remember, in Massachusetts, it's now legal recreationally. In Connecticut, it's legal medicinally. My prediction in Connecticut is that marijuana will likely be recreationally legal within the next year or two. It could be as soon as this session. The General Assembly's in session now. Now that the Democrats have control of the General Assembly, firm control, and Governor Lamont is in place, I think you can expect to see recreational marijuana legalized in Connecticut within the next session or two. So that's coming down the pipe. And again, when that happens, we're going to have to revisit drug and alcohol policies for employers. Absence and tardy policies. I don't think this falls under should. I think this is a must, because I think it's very important to lay out what the expectations are for call-out procedures, for use of sick leave, because there's a lot of litigation over that. Dress codes. Dress codes aren't applicable for all employers, but if it's relevant to your workplace, you want to include a dress code. Computer and email usage policy. I like to include these pretty much for all of our employment handbooks at this point, unless it's really an employer that just doesn't use any electronic devices, which at this point is so few and far between. With the ubiquitous use of electronic devices, I think it's just helpful to have a computer and email usage policy that addresses the employer's expectations concerning the usage of any electronic equipment that either the employer provides or that employees might bring into the workplace to utilize for work purposes. Hot topics in work rules. Okay. Anti-harassment policies. We talked a little bit about it, but we're going to go in a little more depth now. The Me Too movement has really highlighted harassment issues across the country. I mean, you read about it in the paper pretty much every day at this point. Inappropriate conduct engaged in the workplace, outside the workplace. Lots of very high-profile individuals are being swept up in the Me Too movement. There was just an article in the New York Times yesterday, a long article about a rock star who allegedly used his power and influence to engage in inappropriate conduct with other female aspiring musicians. So this is something that we're seeing every day, pretty much every day, in the newspaper. So it's a ubiquitous issue, and it's really highlighted anti-harassment policies in the workplace and whether employers currently have adequate anti-harassment policies, and on a macro level, whether there's adequate statutory provisions on the state and federal level to combat unlawful harassment and gender-based discrimination. So one thing I wanted to highlight, and as an example, and I think we're going to see more and more of this copycat legislation, is New York State recently issued model sexual harassment policy, so that as of October 2018, most employers in New York State must adopt policies that meet the minimum requirements of this new New York State law. Now, the New York State minimum standards state a policy must include a number of different things, and this is a little more robust than what I had pointed out earlier, which I thought were some of the bare bone essentials of a anti-harassment policy. But so under the New York State minimum standards, you have to have a policy that prohibits sexual harassment consistent with guidelines that have been promulgated by the New York Department of Labor. Your policy needs to provide examples of prohibited conduct. It needs to include information concerning available remedies. It needs to include a complaint form. Your policy needs to include a procedure for the timely and confidential investigation of complaints that ensures due process. It needs to inform employees of their rights of redress and applicable forms for adjudicating sexual harassment complaints both administratively and judicially. It needs to clearly state that sexual harassment is considered unlawful employment misconduct, and that sanctions will be imposed on individuals engaging in sexual harassment, and supervisory and managerial personnel who know about the behavior and allow it to continue. Policy needs to also clearly state that retaliation against individuals who complain of sexual harassment or who testify or assist in any investigation or proceeding involving sexual harassment is unlawful. There's a lot of requirements there, and one thing I will say for anybody who's interested in this or operates in New York State and to date is unaware of this requirement, we do have a blog post on our Mertha Employment Law blog detailing this requirement in more detail than I'm discussing today, and also providing links to applicable model policies that have been promulgated by the New York Department of Labor, other requirements under this new New York State law. It's not just the policy, which is what we're focusing on today, but there's also a requirement for sexual harassment prevention training applicable to New York State employers as well. So for anybody interested in that, you can either contact us after or just visit our employment law blog, and there's a lot of information on that there. But as you can see from this New York State requirement, this is it's a pretty onerous and broad requirement for a sexual harassment policy. My recommendation would be to broaden it to include anti-harassment and not just sexual harassment, so that it's clear to all employees that any type of harassment based on a protected category is unlawful, and making clear that there are avenues for redress for such unlawful harassment. One thing I wanted to point out is that Massachusetts, Rhode Island, and Connecticut all have varying requirements concerning sexual harassment posting and policies. So to the extent that you're operating in any of those jurisdictions and you're unaware of those requirements, I suggest that you seek out legal counsel to make sure that you aren't out of compliance with the varying mandates of Massachusetts law. Massachusetts and Rhode Island's statutes are pretty similar, or Connecticut law concerning sexual harassment prevention. And just to go back to that, I don't think that this graphic really has anything to do with sexual harassment, but I couldn't find anywhere else to put this in the presentation, and it's a work rule that I think everybody would like to see, but unfortunately it's not something that I think we should implement at any employment handbook, because for a number of various reasons, but I thought it was amusing. Another hot topic, and I think this is actually particularly relevant to Connecticut, sick and family paid leave. And for those of you that don't know, one of the agenda items for the General Assembly this session in Connecticut is paid family leave. There's already Connecticut Family Medical Leave Act, which provides for unpaid leave for various ailments or circumstances. It seems like that paid family leave is either the number one priority. I shouldn't say that it seems like. It is the number one priority of the General Assembly this session, because Senate Bill 1 is paid family leave, and generally the Senate Bill 1 is reserved for the number one priority of the party that is in power in the General Assembly. So Senate Bill 1 concerning paid family leave is on the table. There was a hearing on it yesterday at the General Assembly. Sounds like it's moving forward. The bill in its current format would require employers with one or more employees to participate and offer up to 12 weeks of paid family leave. There's a lot of other provisions in there that I don't think warrant discussion quite yet, because we've got a long way to go before this particular bill is implemented, and I think it will be subject to revision as it passes through committee and winds its way through the General Assembly. But I just want to put that on everybody's radar that I think that Connecticut will pass a Paid Family Leave Act this session, and that's going to be something that we need to account for in handbook policies, I'm certain. Massachusetts already has such a statute. Rhode Island has a paid sick leave statute. Connecticut already has a paid sick leave statute that applies to employers with 50 or more employees, and but it only applies to what are called service employees, which is a defined term of art, and there's an entire list of examples of service employees. But there's a whole regimen of accrual issues and usage issues under the Connecticut Paid Sick Leave Act. So, I think the overarching point here is that if you're an employer that operates in a state with one of these sick or family leave acts, paid sick or family leave acts, it's important to maintain a clear written policy on how the employer handles such leave. And if you're conducting multi-state operations, you may need separate policies for the relevant states due to the differing requirements, because they're not all the same. Accrual issues are different. The amount of leave, the amount of pay, the number of the eligibility requirements, they can differ from state to state. And like I said, we don't even know what the Connecticut one's going to look like yet, if in fact it is implemented. Important considerations in drafting paid sick and family leave policies: make sure that you define eligibility, set guidelines for accrual and usage, discuss carryover issues in your policy, interaction with other leave policies, accrued vacation, other forms of PTO, whether there's concurrent usage, whether they're exhausted concurrently, prohibit retaliation for use of statutorily protected leave. These are all some of the issues that you want to consider when drafting a paid sick and family leave policy. But probably the most important consideration is looking at the applicable statute and making sure that you're in compliance if you are subject to such a statute. Okay, we're going to turn to a different topic, and now we're going to talk about the NLRB, the National Labor Relations Board, and work rules. And the National Labor Relations Board is the federal administrative agency that oversees the National Labor Relations Act, which in general governs union relations, but it's not only applicable to unionized workforces. Section 7 of the National Labor Relations Act provides rights to employees, whether they're unionized or not. And it provides, for example, the right to self-organization, to form labor organizations, to bargain collectively, to engage in concerted activities for the purpose of bargaining or other mutual aid or protection, as well as the right to refrain from any or all such activities. And generally, it protects the right to discuss terms and conditions of the workplace. So that kind of sets the stage for our discussion of the NLRB and work rules, because we want to keep in mind that employees have these protected rights under Section 7 of the National Labor Relations Act. So, the NLRB and work rules. 14 months ago, approximately, the National Labor Relations Board issued a decision called the Boeing Company, which established a standard for assessing when an employment policy passes muster under the National Labor Relations Act. Prior to the Boeing Company, there was a different test in place that stemmed from a decision called Lutheran Heritage that was issued in 2004. It was a very broad test that, in my opinion, created a lot of confusion for employers. And really, the Lutheran Heritage standard was whether a policy, any particular employment policy, could be reasonably construed to violate the National Labor Relations Act. And if so, that policy was unlawful under the National Labor Relations Act, and an employer could be subject to various damages under the National Labor Relations Act. So that was a very broad policy because it didn't look at whether a policy, the intent of a policy, whether it was intended to interfere with Section 7 rights. It didn't look at whether any particular policy actually interfered with Section 7 rights. So it didn't look at the intent or the practical effect of a policy. It simply looked at whether a policy could be reasonably construed to violate the National Labor Relations Act in a very hypothetical manner. And as I'm sure you can imagine, the board was able to look at many policies and say, while this policy has not actually been used in a manner to violate Section 7 rights, and while there's no evidence that there was any intent that a rule was implemented to violate Section 7 rights, we can read it as we can read a hypothetical into it where it could violate Section 7 rights, so we're going to say it's unlawful. Created a lot of uncertainty for employers. It was very difficult to draft policies that you could say with any certainty would pass muster under the National Labor Relations Act. Created a lot of work for me and my colleagues because we were always trying to work with our clients on how to draft defensible policies in light of this really vague policy that was hard to predict. So under the Boeing Company in December 2017, when administrations changed, the composition of the National Labor Relations Board changed as well, and a Republican-leaning National Labor Relations Board was put in place, and one of its first major decisions was this Boeing Company decision, where it implemented a new test that overruled the Lutheran Heritage test, the reasonably construed to violate the NLRA test, and implemented a balancing test that considers various factors. So under the Boeing test, the board looks at the nature and extent of the potential impact of any particular work rule on employee rights and legitimate justifications associated with the work rule. So to assist with the balancing test, the board implemented or defined 3 categories of employment policies, and we'll take each of those in turn. The first one is rules that are generally lawful to maintain. So these are lawful rules that either don't interfere with NLRA protected rights or for which the potential adverse impact on protected rights is outweighed by the employer's justifications for the rule. And this is, just to talk, going back to Boeing a little bit, and as with in Boeing, a no camera rule was at issue, and at the administrative level, before it reached the National Labor Relations Board, the administrative law judge said that the no cameras at work rule was unlawful under the National Labor Relations Act because it could be reasonably construed to infringe upon Section 7 protected rights. For example, taking photos of workplace conditions to then engage in concerted activities to improve those conditions. But in Boeing, there was no actual evidence that the rule had been applied in a manner to infringe upon Section 7 rights, and there was no evidence that there was any intent to infringe upon Section 7 rights. It was just this hypothetical that it could. So now, under Category 1, this no camera rule passes muster because it's a law. The board now is saying this is a lawful rule that doesn't infringe upon National Labor Relations Act protected rights, and that even if there is a slight chance that this no camera rule has the potential to implicate Section 7 rights, the legitimate business justification of Boeing in preventing cameras at work and protecting trade secrets, confidential information, is outweighed by the slight chance of infringement upon Section 7 rights. Category 2, rules that should be scrutinized on a case-by-case basis as to whether they would violate National Labor Relations Act rights, and if so, whether there is a legitimate justification for the rules. Category 3, just facially unlawful rules that prohibit protected activity and for which the harm to workers' rights is not outweighed by any justifications for the rule. An example of this is a rule that prohibits employees from discussing their benefits with each other. So that was Boeing, and Boeing really was a game changer for assessing workplace rules because even though it was issued by the National Labor Relations Board, which is an administrative agency that is generally associated with union activity, it impacts all different employers because the Section 7 rights don't apply just to unionized employees. It applies to both union and non-union employees. So really, this is really a game changer for workplace rules, and it was very important because now it's providing what is, in my opinion, a much clearer framework for assessing rules. And now, post-Boeing, in June 2018, the General Counsel of the National Labor Relations Board actually issued guidance on handbook rules post-Boeing. And one of the things that the General Counsel said is that going forward, ambiguities in rules are no longer interpreted against the drafter, and generalized provisions should not be interpreted as banning all activity that could conceivably be included. And really, the General Counsel noted that the board had severely criticized the Lutheran Heritage test and its progeny for prohibiting any rule that could be interpreted as covering Section 7 activity as opposed to only prohibiting rules that would be so interpreted. So let's go through some examples of what the board, so just backing up a little, in this General Counsel memorandum, the memo was issued in June 2018, GC 18-04 for anybody that's interested in going and reading this. And really, if you're in HR or you're dealing with drafting workplace rules, I think it's very helpful to read this because it provides a really great framework for how to assess analytically workplace rules. So here, some lawful examples of Category 1 rules. Civility rules, lawful examples, behavior that is rude, condescending, or otherwise socially unacceptable is prohibited. Disparaging the company's employees is prohibited. Rude, discourteous, or unbusinesslike behavior is forbidden. These are all examples that the General Counsel of the board has now said these are examples of civility rules that are lawful Category 1 rules to maintain. Now, word of caution, if these facially lawful rules are implemented in a way that is meant to impact Section 7 rights, they can still be unlawful, but these are facially lawful civility rules. So as long as the intent is not to interfere with Section 7 rights and the policy is not implemented in a way so as to interfere with Section 7 rights, these examples of civility rules are going to be lawful going forward. No photography rules and no recording rules. Lawful examples. The Boeing rule at issue, use of camera-enabled devices to capture images or video is prohibited. Employees may not record conversations, phone calls, images, or company meetings with any recording device without prior approval. Employees may not record telephone or other conversation that they have with their coworker, managers, or third parties unless such recordings are approved in advance. These are all examples of lawful no photography rules and no recording rules that the General Counsel of the NLRB has set forth. Another Category 1 rule that is lawful to maintain, rules against insubordination, non-cooperation, and on-the-job conduct that adversely affects operations. All of this might seem intuitive, like you might be sitting there saying to yourself, shouldn't rules against insubordination just be lawful per se? Well, under the Lutheran Heritage test, no. I mean, there were cases where insubordination rules were coming out as unlawful. It was a very difficult standard to assess, and it was hard to make any judgment of predictability concerning any particular rule. But now we have these examples of lawful policies. So being uncooperative with supervisors, or otherwise engaging in conduct that does not support the employer's goals and objectives is prohibited. Another example, insubordination to a manager or lack of cooperation with fellow employees or guests is prohibited. The general counsel explained, during working time, an employer has every right to expect employees to perform their work and follow directives, and that on balance, insubordination rules that lack any reference that would indicate Section 7 activity is forbidden. The board should not presume any impact on National Labor Relations Act rights. And even where there is some ambiguity, it's likely that the employer's interest in maintaining discipline and production will outweigh any chilling effect on Section 7 rights. Disruptive behavior rules. Lawful examples. Boisterous and other disruptive conduct is prohibited. Creating a disturbance on company premises or creating discord with clients or fellow employees. I could tell you under the Lutheran Heritage Standard, this one would have been difficult because creating a disturbance could be seen as impacting Section 7 rights, because striking or trying to organize a union could be seen as creating a disturbance on company premises. But now the board is saying that the legitimate business justification of such a rule on balance outweighs the impact on Section 7 rights. And the board actually, the general counsel has actually said that the majority of conduct covered by disruptive behavior rules is unprotected roughhousing, dangerous conduct, or bad behavior, and that even if employees would read such rules as applying to strikes and walkouts, employees would not generally refrain from such activity merely because a rule bans disruptive conduct. So we're running a little short on time, and I still haven't gotten to best practices, so I'm going to go a little faster through examples of these rules. Rules protecting confidential, proprietary, and customer information or documents. I've included some examples of lawful policies. Rules against defamation or misrepresentation. Lawful examples. Misrepresenting the company's products or services or its employees is prohibited. A rule stating do not email messages that are defamatory. Again, and logically, it just might seem that these should be facially lawful, but under the prior test, they were not, and now the board's signing off on them. Rules against employer logos or use of employer property. There was a lot of dispute about this under the Lutheran Heritage Test, and now, so long as these rules aren't facially offensive to Section 7 rights or implemented in such a way, they should be lawful. Rules requiring authorization to speak for the company, not about the company, but for the company. These are going to be Category 1 rules. Rules banning disloyalty, nepotism, or self-enrichment. Rules, okay, and so those are all examples of Category 1 rules now. Category 2, though, rules warranting individualized scrutiny. So, some examples are broad conflict of interest rules that do not specifically target fraud and self-enrichment and do not restrict membership in or voting for a union. Confidentiality rules broadly encompassing employer business or employee information. And really the key there is the breadth of the confidentiality rule. You want to make sure that it's narrowly tailored to fit a legitimate business justification and that it can't be read so as to encumber or to offend Section 7 rights. And really, I'm not going to read each of these examples, and we'll provide the slides for you to read on your own. But really, the legality of the Category 2 rules are going to depend on context. And you're really going to have, these aren't going to be facially lawful. These are going to be the kinds of rules that need individualized scrutiny depending on employer circumstances. That's me trying to figure out all of these different rules and how to advise my clients, because even though the Lutheran Heritage Test is gone, it's still a little difficult. We'll talk about that in a second. But the final thing, the Category 3 rules that are just facially unlawful, rules against joining outside organizations or voting on matters concerning the employer. these, basically these are rules targeting employees from joining unions. These are going to be intuitively unlawful on their face. Legitimate, and so for any type of Rule 3, Category 3 rule to pass muster, you're really going to have to show some sort of legitimate business interest that significantly outweighs Section 7 rights, and I haven't seen any cases that have come down like that yet. So the impact of Boeing in the NLRB memo. Key questions: why does the employee have a particular rule? What's the business justification? Is it overly broad? If the justification is just to restrict employee Section 7 rights, stop, go back and try again, because it's going to fail. It's not going to pass muster with the board. All right, let's go through some best practices as we've got 5 minutes left. Provide robust at-will disclaimers. Do not promise specific terms of employment. Do not guarantee employment. Identify the individuals in the organization with the authority to alter the at-will nature of employment. Make sure the acknowledgement form references the at-will nature of the employment relationship. Include contract disclaimer language. Make sure to give the organization flexibility in drafting and implementing policies at its discretion. Disclaimer language is only useful if it is clear and specific. Make sure to require handbook acknowledgments. All new hires should be required to acknowledge receipt and understanding of an employee handbook. When a revised handbook or policy is implemented, make sure to obtain updated acknowledgments. An important point, without some form of acknowledgement, the employer is not going to be able to prove receipt. So there needs to be some mechanism, whether it's an electronic dissemination that accounts for the dissemination receipt, whether it's just a handwritten signature on a piece of paper at the end of the handbook that's then collected and stored in a personnel file. You need to make sure there's some sort of mechanism to collect these acknowledgments and maintain them. Translate policies for English as a second language employees. Because again, if your workforce doesn't understand the policies because they can't read them, what good are they? And that might seem intuitive, but I've dealt with that situation, and I've seen it in cases where employees, they had good claims because they said that the policies weren't translated so that they could understand them. Customize your handbook for your company. Do not use stock handbooks that you pull off the internet. Again, I will tell you, I have a lot of clients that come in and bring me stuff that they pull off the internet and say they've been using it, and it's either just bad or it's not tailored to their organization, and it's just not useful if you're not customizing your handbook for the needs of your company. A lot of people try to cut corners by just pulling stuff off the internet, but it's just not a good idea, and I think it just creates more problems than it solves. Avoid overly specific provisions that eliminate the flexibility to implement discipline as necessary. Benefits policies only provide brief descriptions of eligibility benefits in the handbook itself. Stay aware of state and local requirements. If you're a multi-jurisdiction employer, it's just of paramount importance because it's always changing. Review and update handbooks on a regular basis. Don't let it collect dust. 2 final important points, and I'll start with the most important one. Implement and follow your employment policies. They're no good if you don't implement them and actually carry them out. I mean, you can have a handbook, but if you don't follow it, what good is it? Make sure that you use it because it can mitigate litigation risk, it can enhance your company culture, it can enhance employee morale, and it can set a positive tone for the workplace. And final point, when in doubt, consult with experienced labor and employment counsel. This is dense material, it's constantly evolving, and you don't want to be caught on the wrong side of the law. So we've got a few minutes, we've got 1 minute for questions, but I can go over if necessary. So let's see if there's any questions. Okay. Will we be receiving a copy of this presentation? We had something come up at work and we're a few minutes late joining. Yes. Everybody will be receiving a copy of the presentation after, and if you have any questions or you want to discuss any of it, feel free to contact me. My contact information is on the first and last page of the presentation. Well, I think we're out of time now. Unfortunately, it is 1 o'clock by mine, and I don't want to keep anybody because I know this is a lunchtime webinar. If anybody does have any questions, feel free to contact me outside of the presentation. I'm happy to talk with you. And other than that, thank you for attending. I very much appreciate being able to present on this topic today. Take care.